All right, welcome back. Last week I told you we were starting a murder trial. Best laid plans of mice and men, I guess Shakespeare or somebody said something like that. That started on Monday. Jury picked, told to come back. The defense wanted to do a stand your ground, and this happens to prosecutors every week. Stand your ground in its concept was a great idea. The legislators sold everybody on it. It is basically, if you are minding your own business, you're at home, you're at the grocery store, and somebody comes to rob you or hurt you or do something to you, that you can stand your ground, you can fight back. As a concept, it's a great idea. The part that makes it not as great is that no prosecutor in South Carolina, I don't know, and that's the only place that we're worried about, but no prosecutor is going to prosecute a person for shooting a man climbing through his window, or pulling up on him at an ATM with a knife. We've kicked those cases forever. If you've got a real right to stand your ground, we kick them because we know not only is it the right thing to do, but no jury in their right mind would ever convict anybody of that. Maybe in New York, maybe in California, but anyway, because of the stand your ground, now every murder trial where you've got a drug seller getting robbed by a drug dealer getting robbed by a drug seller, all of these cases, everybody starts off with a stand your ground, which takes a couple of days. Both of them sometimes are up to no good, the victim and the defendant. But you got to go through stand your ground. And it's a mini trial before the trial. So we started off Monday with picking a jury and then this mini trial. And then we were going to go straight into the trial itself. The stand your ground didn't get over with until Wednesday. So the judge continued that case that I had told you about. We did win the stand your ground. The judge says we are not going to disallow the state from going against your client. So you've got to be ready for trial. But it won't be this week. You were successful in kicking it down the road again. And we'll try that case at another time and bring the same people back from wherever they're from and try to put it together again. Plus, mark my words, the next time they're going to ask the next judge to do another stand your ground. Hopefully the judge will say no, that has already been heard, but we have had several times where the judge said, yeah, sure, go ahead and we'll continue around this roller coaster going, not roller coaster, hobby horse ride going nowhere. So hopefully that won't happen, but if it does, that's what. We had another murder case that came up that we told the judge we could have done in 2 days. 6 witnesses, fairly easy. Several people saw it. We had offered that young man the mandatory minimum on murder. This was a case where a young lady who was working as a dancer slash quasi lady of the night, she had invited someone over for payment to have sex. When that person showed up, it was a robbery, and Leo Watkins ended up shooting the victim in that case. That it was supposed to be a robbery, and it ended up being a murder. it was a really good case against Watkins. He had said that he wanted a trial. He rejected the plea offer. The week before this case, we had offered 36, I believe it was, and he rejected that offer. And then on Wednesday, when the case was called for trial and the 12 jurors were picked, he said, "I want a plea." Well, at that point, we said, "Judge, you know, we have offered 30. We've offered 36. Now we at least need more than 36 because all of these victims have been inconvenienced. They've all come out here." And the judge went along with that and gave him 40 years. So he was looking at anywhere from 30 to life imprisonment, and he received a sentence of 40 years. You might be interested in what happened to the lady, Katrina Bedjan. She set the thing up. Of course, she set up a robbery. She did not have a gun, did not shoot the victim. She was actually outside in the car with the victim when Leo Watkins came up and started the robbery. She pled guilty back in March to attempted armed robbery. She was facing up to 20 years for that, and the judge gave her a sentence of 15 years. She'll have to serve 85% of that before she's eligible for parole. Again, we've talked about this before, but there's been quite a few questions, and it is a complicated matter. But when it's murder, it is day for day. It is 30 to life. Possibly you could get the death penalty for murder, but we'll just say 30 to life for standard murder. That is actually 30 times 365. It is day for day for that sentence. If it is manslaughter or armed robbery or attempted armed robbery or rape or basically any very serious offense, kidnapping, but not murder, they call that no parole. And that is a misnomer. I didn't come up with that. That is the state telling you it's a no parole offense. It's a most serious, but that's 85%, and then you would come up for parole. And then if it's a violent type charge, but it's not most serious, and there's only a few of those, but that is, you could be eligible for parole a lot sooner. The nonviolent stuff like breaking into cars, forgery, bad checks, you could be eligible for parole in 1/4 of that sentence there. So it is complicated. I didn't come up with it. That's why I always say I'd rather have truth in sentencing so that I can tell you a time and that would be it. But as I mention on this program all the time, I'm here to tell you the truth. I'm here to try to demystify all of this, and you can be just as mad as I am about it, and that's fine. I don't like it either, but that's the legislature that sets these standards. Murder is day for day. Manslaughter, kidnapping, armed robbery, attempted armed robbery, that's 85%. Anything else, it's kind of a hodgepodge, and it's up to the parole. But it goes down to 1/4, which is nonviolent. So 10 years on a nonviolent sentence, maybe 2.5 years, they would come up for parole. We have pleas this week, so I'll let you know about any big pleas that came around next Monday.